Hello, good evening to all our attendees for joining us tonight, and thank you for joining us on time. Now, today's topic is perhaps a very, very serious topic and one of the most sensitive that we have done so far. The topic is on child abuse, how to prevent it, and what can you do. Now, let me introduce our series of webinars for a moment. This series of webinars is called Apparently by Grander Together. So it is a series of panel discussions between people across generations, bringing their professional or personal perspectives to help strengthen intergenerational families. So we are very grateful for the partnership of Care Corner, and we are also grateful for the support of Mums for Life, Dads for Life, and SG Families. A little bit more about Grander Together. It is an initiative that aims to cultivate stronger intergenerational families in Singapore, and this is an initiative of Cultivate SG. Let me introduce the panelists for today. Our first speaker will be Mr. Martin Chok. He is Deputy Director, Family and Community Services at Care Corner. With 20 years of experience in the social service sector, Martin has effectively managed a diverse range of clientele, including complex family violence cases, children and youth-related cases, mental health cases, and marital cases. Our second speaker is Bill. Bill is an associate director at Calco Law LLC. He has represented clients in a wide range of family disputes. Although he believes in collaborative dispute resolution, he is equally capable of successfully arguing and resolving contentious proceedings to reach a fair and just outcome for his clients. Now, one important note about this webinar, I know that some of us may have in mind certain incidents or cases of child abuse, but I would just like to make clear that this webinar is not intended to discuss any particular incident of child abuse. We have some exceptions, and that exception is that the panelists may cite certain cases for the purposes of explaining the relevant legal or other principles. So with that, I would like to hand the time over to Martin, and Martin will share with us about the practical and social aspects of this entire topic of child abuse and what we can do about it. So, Martin, over to you.
Okay, thank you, Darius. So good evening, everyone. I'm Martin. So tonight I will share on a wide range of content for 15 minutes, and thereafter, I think that Bill will take over, and there'll be a time of Q&A. So my sharing will be quite broad-based, and we can zoom in a bit more during the Q&A time. So I'll be talking about the types of abuse, the signs to look out for in spotting child abuse, possible reasons for the abuse to happen, possible dilemmas or internal conflicts that people face in the cases that I work with, and what can the family members or the members of the public do when you face such situations, or you come across such situations, or when people tell you about it. And if I have a bit of time, I will also share about what we do at a Protection Specialist Center. Okay, so for us, for this topic, I think there are two groups of people that I've classified broadly. One, you are a family member that come across child abuse, or you can be a member of the public. You can be a neighbor, you can be hearing from your friend about such situations happening. So firstly, the types of abuse, I would like to state that it does not mean that only physical abuse is abuse. Actually, the types of abuse in the legal terms, and I think the lawyer will cover later, is quite wide-ranging, and the law has also made some provision for it already. It covers psychological abuse, it covers verbal abuse, even financial abuse. And in the area where the children are involved, there are actually two areas in which I would like to share. One, the child or children could be a victim of the abuse, meaning the parent or parents hit them. It can be with a belt, a hanger, cane, and there are very visible bruises on them. Bleeding, they can fall, they can be pushed and suffer fractures, sprains, broken bones, visible bleeding cuts on the head, and there's blood. Or the children or the child can also be a witness of an abuse that's happening at home. For example, father and mother are quarreling, throwing things at each other, father hurts mother, and the child has witnessed all these things. And therefore, the impact that the abuse has caused the child can be long-lasting. It can cause very deep trauma upon the child. And the child might take a long time, and the child requires psychotherapy to recover from it. So this is actually the scope of what we mean by abuse. It can also constitute, it can also be a form of neglect. For example, denying the child basic care or food, not taking care of the child. Um, for example, there can be a case where the child's parents could be drug addicts and neglect the child in terms of food, basic care like changing the diapers, not bringing the child to school, not bathing the child, so on and so forth. So I just want to set the context. So in particular, signs that we can look out for when we come across abuse or when your friends talk to you about it or family members talk to you about it. As professionals, what we look out for are sudden changes in the behavior of the child. For instance, if the child is very chatty, very courteous, sorry, excuse me, he or she likes to, is very responsive to you, and suddenly the child becomes very withdrawn, isolated. I think this is a telltale sign or something that we need to pay particular attention to. Of course, the child can be sick, can have a bad day or feel moody, but what we are saying here is we have to be vigilant in terms of what happens to our child's behavior, because the child could have been abused in the childcare center, in the school as well. So there are just so many possibilities when we talk about child abuse. So I just want to share possible scenarios. On the other hand, the child can also be especially clingy or craving attention towards adults. So again, we are talking about the sudden changes in behavior. If the child previously doesn't behave this way, and suddenly you find that the behavior is out of the norm, this is something that we have to pay attention to. And a possible case is sudden prolonged wetting of the pants in the middle of the night. This could be a form of trauma. The child is feeling very anxious, very scared. Something has happened, something that we have to take note as well. From a neighbor's front, if you continuously hear loud noises, parents quarreling, things being thrown, of course, we're not talking about accidental things falling on the ground, but day in, day out, every night, you hear two adults shouting at the top of their voices, or even caning the child, and the child is crying, wailing, asking for help, pleading with the parent not to cane him or her. These are all signs for possible abuse. So what happens what actually causes all these things? So very briefly, some possible causes are the parent who abused the child could have been a victim of an abuse himself or herself. They could have been witnesses of abuse when they were growing up, and thus this causes them to normalize violent behavior. They might think that hitting people or using violence or shouting, using very abusive language is a way of coping because this is what they've witnessed, this is what they've been brought up. They don't think that there's anything wrong in doing so. And there could also be a possibility of poor coping mechanisms. There could be many stressors in the life, financial stress, there's a poor marital relationship, husband and wife don't get along too well, and they will vent their frustration on each other or on either parent or possibly on the child. So there are many reasons why abuse can happen, but I'm just stating some possible ones because there are also people who have been witnesses of abuse or they've grown up being abused and they grow up okay. They have sought help and actually they grow up fine. But these are some possible reasons. They normalize violence. They don't think that violence is anything wrong. They use violence as a way of coping with their own stressors, coping with failure, coping with things that don't go their way. And in the course of the work, there are some possible dilemmas that I come across and which we hear. Some very common ones are this is the other family's issue. It's a family issue. Let's not poke our noses into their affairs. Uh, let's not interfere in somebody's family issues. Some possible reasons or some comments that I hear from members of the public is we don't want to break up a family. They are afraid if I make a report, if I go and approach a particular family who is in distress, and I cause the father to be locked up or taken away by the police, the family is broken up. I don't want to be somebody who does that. I prefer to mind my own business. Yeah, so these are some things that we hear people talk about. However, I just want to put in a new perspective when we work with our clients in terms of what we can do, in terms of what everybody here who is part of the webinar can do, and you can also spread a message around, is the idea of making a report is actually to help the family in distress because the family does need help. The person who has abused a child or even the wife beats the wife or the wife beats the husband, they need help because we believe that there's no one who is violent 24 hours of the day. And there are times when they are good. They love their children, they dote on them, they treat them well. But there are also times when they are taken over. They cannot control their emotions because of stress. There are also other factors like could be drugs. They could have a mental illness that is not treated. So they need help. And so if we don't help the family or if we don't intervene or in our slogan is actually break the silence, the child might be killed. Somebody in the family might be killed. They might be seriously injured. And we don't want to see that. We don't want to, we really want to see families functioning well. We want to see a loving family. So what we want to do is we want to reinforce the positive behavior of the family member. And thus, if you manage to break the silence, I think that's a great thing. Many a time, people are afraid to make a call. We hear some questions. What number to call? Who to call? What happens if I call? Will my identity be disclosed? I don't want to break my good relations with my neighbor. I don't want to, if it's a family member, I don't want to report my own child. For example, if it's a grandparent and the son or the daughter is abusing the grandchild, the grandparent might be worried. I don't want to break up the family. I don't want to go and report on my own children. Yeah, so I just want to offer some explanation and illustration on what happens So the number to call if you do happen to spot bruises, or you notice unusual behavior in your grandchild, your neighbor's child, or even your own child, you can. The number to call is actually the National Anti-Violence and Sexual Harassment Helpline, NAVH in short. The number is 1-800-777-0000. 1-800-777-0000. So what happens when you make a call? You call this NAVH helpline. Typically, they will ask for your name and your contact. For the primary reason, if they need to verify certain information with you. Rest assured, the identity of the caller will always be kept a secret. We tell people that making a report is actually our responsibility. Investigation is the responsibility of the authorities. It's the responsibility of NAVH. So even though you're in doubt, there's actually no wrong report. You're not going to get into trouble if you make a wrong report. You're not going to be penalized for calling on for reporting about your neighbor or your other family member. So when you make the call, typically they will ask you your name, your contact. They will ask you for details about what happened. So I think this is where observations like the frequency of the abuse, the extent of the abuse, what you have heard. You hear loud voices, you hear things being thrown about, you hear children wailing, crying, pleading for help. So these descriptions are helpful. You can provide them to NAVH. They ask you for the location because this is going to result in the investigation if there's a need to. So NAVH has officers that can go up and make home visits. So what they will do is, again, breaking the silence. Go to the particular household, knock on the door. They want to look for so-and-so. Father, look for mother. They receive a report. They want to check if things are okay. So then they will conduct their own assessment. Of course, if the abuse is so serious, you come across people with the child has bleeding, broken hands, broken arms, broken legs. The abuse is just too bad. You have to call the police. 999. Police will come up. Sometimes it might result in an arrest. Sometimes they will give a warning. So it all depends on the situation. But I think I want to stress again, it's about breaking the silence. When there's a real abuse going on, there's a lot of shouting, throwing of things, hitting of each other. And if there's someone there to intervene at that point of time, it actually makes a lot of difference, because what we want to stress on is timeliness of the report. When the report is made at a timely fashion and there's an intervention, the victim, for example, probably the mother, is more likely to seek help. You delay it for too long, you let it run for another day, again, the behavior is being normalized. My husband is a good man. He loves me so much. He loves the children so much. He's just a moment of folly. It's all my fault. So these are some situations in which we face. There might be some self-blaming. They will normalize things. They will make excuses for the abuser. But that's why if the report is made in a timely fashion, if it's there and then somebody goes up to the door, when the abuse is fresh, there's a higher chance that help can be administered. And when NAVH makes a report, they conduct the investigation, or when the police makes the house call, goes up to the flat, they can make the referral to appropriate agencies like us, Care Corner. We run a protection specialist center. They can also refer the case to the protective services under MSF, or even the Child Protection Specialist Center. So, and we can administer the appropriate support and intervention to the family. So I'll stop here. If there are other questions, I will take it at the Q&A time. Thank you.
Hey, thank you very much to Martin for sharing. And indeed, I think this is something which is important to emphasize the idea of breaking the silence and, of course, timely intervention, which can save lives. Now, there was a number that Martin shared with us. So I put a text in the chat in case you missed it. So it's 1-800-777-0000. That's the National Anti-Violence and Sexual Harassment Helpline, NAVH. So you can check out the chat group and you can go to the MSF website for more details about this number. Now, I'm going to hand the time over to Bill shortly, but I noticed that there are quite a number of questions in the Q&A segment. So please continue to ask those questions. If you look at the bottom of your screen, there is this tab called Q&A, and you can see that there are a number of questions already on the Q&A panel. So please, if you have any questions that arise in the course of any sharing, or if any burning questions you would like to ask any of our experts today, please feel free to ask them. And I think we will turn to that when we come to the Q&A segment. So without further ado, can I hand the time over to Bill to share more about the legal aspects of this particular issue of child abuse and what we can do to help. So, Bill, over to you.
Hi, everybody. Good evening to everyone, and my name is Bill. Just do give me some time. Let me just flash my slides on the screen. I hope everyone can see it. So it's a pleasure to be here, and I think I just want to share a bit about, at least from the legal perspective, what can really grandparents do in cases of child abuse or even in cases of suspected child abuse. So I believe that Martin has already gone through actually quite a fair bit of important things, and I just want to also cover something. I will just overlap in some way. So generally, what I will be covering today in this short time that we have is these three parts. So the first part will be family violence. The second part is whether or not can grandparents become guardians of the children, and lastly, whether or not grandparents can they adopt their grandchildren. So in cases of family violence, well, there are two ways to react to it. The first way is either whether or not can the grandparent file a personal protection order on behalf of the child. And the second one, which Martin earlier talked about, is whether or not a complaint can be made to the Child Protective Services, or whether or not it can be made through any family social services, such that it can be referred to the Child Protective Services for any form of intervention. So currently under the new framework for personal protection orders, what really is important to know, okay, is that number one, a personal protection order is for the purposes of protecting a child, or rather any family member from another family member. And of course, the huge difference here is that if a person were to breach an existing personal protection order, that person will be liable to a fine or an imprisonment. Okay, so I'm not sure whether or not in the course of your work or in your experience, you have seen that sometimes violence between family members, police actually may not intervene in such cases. And they usually say that, oh, you don't have a personal protection order, therefore we cannot do anything. So, and this is where a personal protection order is crucial, because in cases where it is not severe enough for the police to actually have any intervention, the personal protection order will compel the police to actually investigate and whether or not there has been a breach committed by the perpetrator in that case. So, as Martin earlier pointed out as well, currently under the new or rather the Women's Charter, there are certain amendments that have been made earlier in this year. So the definition of family violence has been quite significantly expanded. So previously, prior to January 2025, family violence was actually narrowly defined as physical abuse. But currently, under the new framework, the family violence is defined as physical abuse, sexual abuse, emotional abuse, and psychological abuse. And if I just just run through very quickly what it states in the Women's Charter. Physical abuse deals with whether or not there's any conduct that has caused, or rather causes or threatens to cause personal injury, threatens a person with death or injury. And for sexual abuse, it includes conduct or behavior that coerces or attempts to coerce a person to engage in sexual activity. Under emotional or psychological abuse, that deals with conduct or behavior that torments or intimidates, harasses or distresses a person, and also causes or may reasonably be expected to cause mental harm to a person. Okay, so interestingly, also one of the amendments that was included was that it also includes conduct or behavior that constitutes abuse that need not be directed to the child. But as long as it is capable of being seen or heard or otherwise perceived by the child, that can actually constitute as family violence as well. So actually, it encompasses quite a broad spectrum of behavior and conduct under the new framework. So, of course, then the question is who can apply, especially if the child is a minor. Okay, so in cases where if the child is below 18 years old, a family member can apply on behalf of the child against the perpetrator or the offender. So if you're looking at grandparents, grandparents will likely fall within this category of family members. But of course, if the grandparent is responsible for caring for the children in any capacity, then of course it will give a much stronger standing for the grandparent to file the personal protection order on behalf of the child. Under the new framework as well, there is quite a varying or rather a large range of orders that can be prayed for in the court as well. So other than protection orders, domestic exclusion orders as well. So domestic exclusion orders, essentially what that means is that it grants the child or any person the right of exclusive occupation in relation to their home. And then we also have stay away orders now, where it prohibits the offender from entering or remaining in an area outside of the house. Okay, so for domestic exclusion, it's within the house, and stay away order is outside of the house. And then there is no contact orders where it prohibits contact between the offender and the victim. Interestingly, there is also electronic monitoring orders now as well, where basically electronic monitoring devices can be placed for care supervision orders. So this specifically pertains to children that are under 18 years old. And the court has the power to decide whether or not the child to be removed from his or her own house and be placed in the care of a fit person for a specific period of time. Counseling orders are also within the court's power, and also mandatory treatment orders where it is. Martin spoke about this earlier, but I just want to run through very quickly. So CPS will only intervene if the child is below the age of 18 years old, and they only tend to intervene in cases of abuse or neglect, such that the CPS needs to intervene and care and protect the child. So these are some of the very common examples where for grandparents, they may be concerned about, especially if they believe that a parent has conducted themselves in such a manner that places the child at risk, or the parent has exposed the child to someone that has posed a risk to the children. Okay, so under this, these are the type of orders that the CPS through the youth court can actually impose on the parents or the guardian. But one crucial thing to take note when matters are being referred to the CPS is that it is not actually within the control of the complainant, okay, as to what orders are being made against the parent or for the child's benefit. So for example, if the CPS or any appointed social welfare officer decides that it is in the interest of the child to be placed in in some form of foster care, the complainant has no say as to whether or not that should be done or not. Okay, that will be entirely within the social welfare officers or CPS's discretion as to what really is in the best interest of the child. So just to move on to the guardianship and whether or not can grandparents exercise guardianship over the child. So one thing to put very clearly first is that grandparents actually do not have the standing to ask for care orders or access orders over children. Okay, so under the Guardianship of Infants Act, only parents have the right to do so. Okay, so you cannot, as a grandparent, you cannot say that, oh, I want to obtain care and control of the child away from the parent. That is something that cannot be done under the Guardianship of Infants Act. However, there is a way for a grandparent to apply to be the guardian of the child, and that is by way of the court extending what we call its wardship jurisdiction. Okay, and the court can only do so, okay, if they believe that the applicant in that case has a genuine interest in the matter. And the second thing is that in order for the court to extend its wardship jurisdiction, it is a very high threshold such that it can only be invoked where a child is in need of protection. Okay, it is meant to be a shield for the child. So in just one very key case, I'm just going to run through it very quickly, UMF and UMG. Okay, in this case, the applicant had filed to be for care orders under the Guardianship of Infants Act. Okay, the child was 7 years old when the grand aunt was actually caring for the child. And when the mother, in this case, requested for the child to return back 3 years later, okay, the grand aunt refused to, and she applied for care orders to be given to her. And the court found that, number one, okay, the grand aunt did not actually have the standing to seek care orders under the Guardianship of Infants Act. And number two, this is the more crucial point actually, is that the child was not in need of any protection because in this case, the parents were fit to care for the child. And there was nothing to indicate that the welfare of the child would be harmed if he were placed in the parents' care. And in this case, the grand aunt's or the applicant's application for care and control was denied. But there are other cases where does wardship jurisdiction actually apply? Oh, apologies. This UMF and UMG, this was a wardship jurisdiction case. Okay, but where cases of wardship jurisdiction applies is in such examples here. So, for example, where a parent, in this case a mother, had left 3 children born out of wedlock in the care of the grand aunt since their birth, and throughout the children's life, the mother has been completely absent. So to the extent that when the grand aunt required to obtain consent from the mother on matters necessary for the children's welfare, for example, their healthcare needs or their schooling needs, the mother was not forthcoming. And in such a case, the court granted the grand aunt's application to be appointed the guardian by extending its wardship jurisdiction. The last point that I want to cover today is on the issue of adoption. Can grandparents adopt their grandchildren? And the court's primary principle or the paramount consideration in such cases is the welfare of the children. So in the case of Risi, and this was a 2023 case, the prospective adopters in this case were the maternal grandparents who were seeking to adopt their grandson, and the child was with them, okay, for quite a number, rather throughout the application. So from when the child was 6 months old, all the way until 2.5 years old. So in this case, the natural mother, she was 18 years old. She gave birth to the child. Her life was not, in good order. to the extent that even the natural father the identity of the natural father was unknown because the natural mother actually had multiple sexual partners at the time that she conceived the child. And interestingly, in this case, in adoption proceedings, the guardian on adoption who had conducted the social investigation assessment in this matter had actually recommended that the child not be adopted by the maternal grandparents. So what happened is that then the case ended up becoming between the maternal grandparents and the guardian adoption who was represented by the Attorney General Chambers. And in this case, the court actually sided with the maternal grandparents in this case and allowed the adoption order to go through. So what the court held in this case is that the paramount consideration, as I mentioned earlier, is the child's welfare for the adoption to be granted. And in doing so, one of the key issues that the court had to balance was whether or not the child would suffer from emotional confusion for the fundamental distortion of the original familial relationship. And to just go deeper into this was a phrase that was used by the guardian in adoption, that they did not find that there were any good reasons, or rather they basically prioritized keeping the original familial relationship between the child and the natural mother in this case. But what the court found was that by doing so would not actually be advancing the welfare of the child. And that was sufficient for the court to award the adoption order to the maternal grandparents. And one thing that the court had also went further to give an opinion on was whether or not it was public policy an issue, or was public policy something that prevented a grandparent from adopting the grandchild. And in this case, there isn't any public policy against such an adoption being granted to grandparents. Okay, so of course, lastly, in order to understand the court's position on this, the court also highlighted that adoptions will not be allowed in cases where grandparents were obstinate or refuses to commit to a workable plan of appropriate disclosure and support for the child. So what this essentially means is that if the court finds that grandparents are not acting in best interest of the child, or has done something that compromises with the welfare of the child, then of course the court will not hesitate to actually dismiss such adoption applications. So just to emphasize again, the main consideration for the court is what is in the welfare of the child. Okay? So that is all that I had to share. I'll hand back the time to Darius.
Okay, thank you very much. Thank you, Bill. Thank you, everyone, for all your sharings. I see that there are a lot of questions right now that have come in. So in that case, why not let's go right to it. Now, I noticed that there are a lot of questions that are asking about whether certain types of actions or behaviors or practices are considered child abuse. So I think I will take them all together later on. Maybe let's focus on one of these questions first, which is probably quite pressing on some people's minds. Martin, if I could ask you this question. When will child protection services take children away from the parents? I think a lot of people are afraid of reporting child abuse because they think the child might be taken away. Martin, any thoughts on this question?
Okay, I will, because I've been reading the questions as well. So I just want to share a few parameters and considerations first. I think firstly, as far as possible, we want to be able for the child to live with his parents or her parents. I think that's the primary consideration, because we definitely don't want to break up families. And if children are being removed, it is usually done as a last resort. So the emphasis here is it is the last resort. It doesn't happen all the time. And even when the child is removed, there's always a plan and a proposal for how the child can be reunited back with the family. Because again, it's about wanting to keep the family intact. So this has always been the basis on how social workers, even at protective services, at the CPSCs, the protection specialist centers, how we operate. A lot of the work, firstly, is of course to ensure safety of anybody who has been abused. It could be the spouse, it could be the child. However, beyond that, the longer term goal that we want to achieve is to build up family resilience. We want the family to be able to cope with stressors. We want the family to be able to talk through things, to have healthy communication patterns. So a lot of the work actually involves that. We want to allow the family to have self-agency, be empowered in making choices and in being able to solve problems. Okay, so I think, so back to the removal of the child thing. For MSF, for removing of the child, this can only be done by MSF Protective Services. Community agencies like FSCs or even Care Corner Protection Specialist Center Project Start, we don't have the power to remove any child. Yeah, so when in saying so, it also means that the threshold for a child being removed is, the bar is actually high. There needs to be a lot of evidence, and the assessment has to be robust for that to happen. So it can be in the form of very severe abuse. Typically it could be physical, visible bruises, bleeding, broken arms, broken bones, severe neglect, child is malnutrition, malnourished. There's an absolute lack of safe and protective figure at home. I think these are some of the parameters, because it's very difficult to say what case can be removed, what case not to be removed. But these are some broad situations that we have seen where children have been removed. Because there's typically a matrix where we are used to assess the extent, the severity, the frequency of the abuse.
Thank you. Thank you for the thoughts. Now, let's go into this question on whether or not certain practices constitute child abuse. Maybe let's take a few at a time so we're not overwhelmed with the long list of different practices. Bill, could I ask you on this? Is caning children considered child abuse under Singapore law? And I think there's another related question of sorts. Is it considered child abuse to confine children in a dark room, for example, a storeroom, as punishment? Okay, Bill, if you could address that, and Martin, after that, if you have any thoughts as well. So, Bill.
Okay, well, it's a tricky one, I must say, because under the law there is no specific provision that says that caning is considered family violence. Okay, but that being said, it all comes down to whether or not the caning, whether or not will it constitute as family violence, such that it has to fall within the definitions which I mentioned earlier. So, for example, if a parent were to cane the child to the extent that it threatens to cause personal injury rather than an intention to discipline the child, then I would think that that would probably fall under physical abuse and under the definition of family violence. Okay, so I think it really depends on the case by case basis. And of course, how the offender had intended it to be, and also how the child had received it also matters. So I hope that answers the question. And maybe coming to the second question about what if a child is being confined in a room on his own. So once again, it's similar. So I would say that in and of itself will not constitute as family violence. However, of course, if it is something that it wrongfully confines the person against the person's will, okay, that will fall under what is considered as physical abuse. Or the other way that I think it can fall under would be if by confining a child in a dark room on its own, whether or not will it torment or intimidate the child as well. So that will also fall under the emotional or psychological abuse limb.
Okay, thank you. Martin, any thoughts on
If
these
I
two?
can add on, I think from the legal aspect, Bill has answered it. As a social worker, I would like to offer a perspective from a more from a social worker's viewpoint. I think for us, we don't recommend caning of a child because actually it's very difficult to distinguish between you cane one time or you cane 20 times. Yeah, I think physical punishment is not something that we will recommend, or because there are other forms of ways to educate and to teach a child. So of course, we might think that it's effective. We also have parents who come and tell us that actually I was brought up that way and I turned out fine. This was the way I've been taught. However, I think we also need to understand about the current ways of disciplining or educating a child, because times have changed. So by confining the child in a dark room or using scare tactics, open inverted commas, scaring a child, it can actually cause longer term effects. The child might develop fear, and in the very extreme situations, it's as what I've been described, like wetting the pants, suddenly exhibit a change in behavior. So I think this is the perspective I would like to offer.
Okay, thanks. So next question, I think I'll pose it to Martin. This is about neighbors. So there are two questions, which are somewhat similar on that. The challenge with the neighbors front is that with each TV setup, it often is very difficult to tell where the cries and screams are coming from, as long as it's not immediate next door. I often hear screams, but it can be anywhere from the opposite block or upstairs or downstairs. It's very hard to tell. There's another question there that's asked, is there such a thing as going overboard in reporting child abuse? What if neighbors are too overzealous in reporting suspected child abuse when it might be usual situations when children are crying or throwing tantrums? So I think it's two sides of the coin, whether, how do you determine? And I think the other one is whether you can go overboard.
Yeah, so I would like to go back to what I've shared. Reporting is the responsibility of the public. The investigation is not our responsibility. The investigation portion is undertaken by NAVH or authorities. So in the instance where it's very difficult to tell where the cries are coming from, where the shouts are coming from, the rule is actually to report it factually, because the NAVH officers are trained to ask questions. You can trust that they will conduct the investigation in an objective manner. So I think for members of the public, please do not feel burdened that you need to give a very accurate account. So this actually goes the same for the overzealous reporting portion. I think we rather have a report that is overzealous, or you make a report that is out of concern, than not reporting. Because again, it's about the breaking the silence. Because if you don't make the report, and what happens if it is really a form of abuse? Yeah, so at least the report is made and investigation can be done. And if it's nothing, it can be just a child falling down, and it can happen. The broken bones, maybe child fall down from a bicycle, it can also happen. At least somebody's there to investigate.
Okay, thanks. Bill, I will direct the next two questions to you, and these I think relate to personal protection orders, I think. So the first question is, can teachers or schools apply for personal protection orders for children? And the second question is, with the types of orders mentioned, under what conditions can a specific order be repealed or revoked or withdrawn? So this question didn't mention what context, but I think it's about personal protection orders.
Okay, thanks, Darius. Okay, so to first answer the question, can teachers or schools apply for PPOs? I think the answer would be no. The only people who can apply for protection orders on behalf of a child has to be a family member or a guardian or a person who is responsible for caring for the child. So in this case, I do not think that a teacher or a school actually falls within this scope of whether or not they have standing to apply. To answer the next question, that would be whether or not can when will the orders, specific orders, can it be repealed, revoked, or withdrawn? So under the current the Women's Charter, so actually it does state that when such orders can be varied, revoked, or withdrawn, and so let me just pull that out. Okay. So one thing that the court has to consider, right, is that number one, if consent is given by the, okay, in this sense, a child can't, but let's say if it's an adult who is giving the consent for the variation or the revocation of the protection order, the court must know that the consent was given voluntarily. So that's the first thing. And the next thing is that there must be a change in the circumstances uh, from when the protection order was made and when an application for the variation is being applied for. So the other things that the court will also consider is nowadays actually for protection orders, it is very common for it to also follow up with a counseling order as well. And how the counseling order assists the court is that a report will actually be adduced to the court for the judge's viewing and consideration. And from the counseling, actually, the court may actually decide with whether or not the order should be varied or even suspended in that case. So generally, this is how the court will look at it. So if it's not consented, then the applicant will need to show evidence of any change in circumstances that warrants the variation of a protection order or a revocation of the same.
Okay, thank you. Next question is for Martin, and I think we'll take this as our last question. So the question goes, what kinds of dilemmas have you seen when grandparents suspect their grandchildren might be abused by their parents? Okay, Martin, over to you.
Yeah, I think this is a very difficult situation for any parent because in the case where you're a grandparent and you suspect that your child is abusing your grandchild, number one, it's your relative and it's your son or your daughter. So the dilemma is real. We don't discount that. What we tell our clients is you have to change, the perspective has to change. It's actually helping your child, your son or daughter, to rehabilitate because obviously they need help. He or she needs help. There are some, it could be a coping issue. They cannot cope with stressors. They could be on drugs. There could be a mental illness involved. So there are many reasons. But I think the change in the perspective is important because if you see it as you're helping your child, we find that it makes a difference and it can actually help in the reporting. Of course, it does take some time. It's not the thinking cannot change overnight, but this is where we will work very closely with the grandparent and actually also share with them that imagine the impact on your grandchild. If your son or your daughter is not given help, they're not being. I think firstly, the law has to come in, and as Bill mentioned, typically there's also a counseling order, and this is where we can work very closely with the person who has harmed the child, and help him or her understand that the behavior is causing harm to your child. And we know that you love your child, but this is not the way that you should love. Yeah, so similarly, for grandparent, we will also point back to the impact that the grandchild might be facing and also imagine the long-term effects the grandchild might have.
Yeah. Okay, thank you. And I think that's a good note to end on. So really about changing our perspectives that when you report suspected child abuse, you're really trying to help people. And I think this is about saving lives, saving people's physical and mental and over integrity, just basically about protecting children as much as we can do. Okay, so with that, I think we have come to the end of today's webinar. So one final note, if I may, just share my screen once again. Just one moment. Okay, so with that, this is a QR code, and if you'd like to follow more of our content from Grander Together, if you'd like to go to our Telegram channel, our Facebook page, our YouTube channel, as well as our website, please feel free to scan this QR code. It will lead you to a series of links that you can use to follow our content and our materials. Now, after you exit this webinar, there will be a pop-up on your screen, which is a survey. So please take some time to fill up that feedback form that will appear on your screen after you sign up. That will really help us to serve you better and address any other topics that would be on your heart. So thank you very much for being such a great audience tonight, and thank you for your active participation. Take care and good night.